When does an injury arise out of employment? Attorneys at KCNS Law Group LLP explain. If an injury arises out of employment, then it is the result of a hazard of that employment, i.e., the injury must have been caused by or linked to employment in some fashion. California requires that a physician must provide evidence as to how the employment led to the specific injury in question. This might require that the claimant provide a medical report describing how the work-related event resulted in their injury. Different jurisdictions can apply varying tests to determine whether or not an injury arose out of employment. Common tests include the increased risk doctrine, the actual risk doctrine, and the positional risk doctrine. California requires that the employment increase the risk that the injured employee would have come into contact with the eventual source of the accident. Some types of injuries can be particularly difficult to determine when it comes to whether or not they arose out of employment. State statutes may instead address causation for these types of injuries. Two common examples of these injuries are the aggravation of a pre-existing condition and repetitive trauma injuries. Other types of injuries that may be addressed specifically under state statutes include acts of nature, occupational diseases, unexplainable accidents, medical malpractice, cancer, and hernias. The knowledgeable team of attorneys at KCNS Law Group, LLP have dedicated their careers to advocate for the rights of their clients. Our client-based approach is concentrated on our commitment to providing individual and strategic representation tailored to our clients' specific needs.